As always with our webinars, we do have to keep them as interactive as we can. So please make use of the chat. If it's something that you think we really need to stop and discuss, put your hand up and we'll stop and discuss the point a little bit more. But what we're talking about today is what do we do with disclosures of family violence when they are disclosed, primarily in family dispute resolution. Before I go any further, I'd like to acknowledge Aboriginal and Torres Strait Islander people as the traditional custodians of country and recognise their continued connection to the land, waters and culture of Australia, and pay respects to elders past, present and to our emerging leaders. I come to you today from the lands of the Gunai people in Gippsland in Victoria. I'm Joanne Law, Director of Mediation Institute. I'm a family dispute resolution practitioner, nationally accredited mediator, trainer and mentor for other mediators. If you wouldn't mind, just use the chat to share who you are, what sort of roles you've got and where you're joining us from. And any specific questions that you hope to have answered today, feel free to in the chat as well. I'll leave you to do that. So what I've got on the topic today is looking at what is family violence, the structure of risk screening. Maybe we'll briefly talk about the changes to the Family Law Act and what they may mean. We'll touch on mandatory reporting and safety planning. And what do we do with risks once they're identified? And if we have time, I hope that we can share some experiences and some strategies from the group, because I can see we've got some very experienced practitioners as well as newer practitioners and students. So there's a great opportunity for some sharing as well. Firstly, let's just get on the same page as far as what is family violence. And of course, it does depend on what legislation we're looking to for our guidance. In the Family Law Act, for the purposes of the family law system, family violence means violence, threatening or other behaviour by a person that coerces or controls a member of the person's family or causes them to be fearful. So most of the definitions across state legislation as well come into those aspects of violence, threatening or other behaviour that causes people to be fearful. So in the Family Law Act, it's got a list of examples that's not meant to be these are the only things that are family violence. It can be a whole range of different behaviours that can cause a family member to be fearful, to modify their behaviour and be controlled by that other family member. The other aspect of family violence in the Family Law Act is exposure of a child to family violence. And again, for the purposes of that act, a child's exposed to family violence if they see or hear family violence or otherwise experiences the effects of family violence. Again, it ranges across a whole range of things. So hearing threats from family members, hearing or seeing an assault, having to provide comfort or assistance after the assault's occurred or the incident. I think so. Some of the language there is probably a little bit out of date if the assault's assuming that it's a physical assault, cleaning up after family members or even being present when the police or ambulance comes. So it's basically exposing children to that sort of environment where they're caused to be fearful. Our evolution of understanding around family violence continues to change. When the Family Law Act first came out, there was virtually no mention of violence and only very vague references to child welfare back in 1975. And any of us are old enough to have a perspective on that. Remember that domestics, as they were called, were tended to be seen as matters for inside the house and not really of any particular concern outside of it, unless there were serious physical injuries. The 2011 amendments to the Family Law Act brought in coercion and control, and the harm to children from exposure to family violence was added. So there was evolution in understanding that it's not just if someone's physically injured that there's harm being caused. The 2023 amendments that have just come into place on the 6th of May, there's been a restructuring of the best interest of the child, which prioritises safety a little bit more than the previous wording did. And it's also added including safety for people who care for the child. There's improvements in information sharing between the federal and state jurisdictions to try and close the gap on some of that information, and some improvement on the systems of use where people were using repeatedly going back to court as a method of causing harm. And it's wonderful. Looks like we've got some people here with us who are really working specifically in the domestic and family violence area. So feel very pleased to use the chat to share your knowledge and resources as we go through as well. So the state laws are also changing. Many of you will be aware of New South Wales that are bringing coercive control into the criminal offences domain, and sometime in the future maybe we'll have a situation where violence against family members or intimate partners isn't seen as a civil matter and is treated as a criminal act the same way it would be if it was against a stranger. I'll jump down off my soapbox now, and I guess looking at, how can people be safe inside their homes and also in the street in Australia. The Family Court has a set of family violence best practice principles in the Family Violence Bench Book. So starting from the principle that family violence isn't acceptable, that safety is a right and a priority in all for all court users, and as a family dispute resolution practitioner, I think that applies to anyone who's using the family law system to try and be safer. Parenting matters involving family violence will be identified early and appropriately managed, and there's certainly been an improvement in the triage and case management principles within the court. All professionals working in or appearing before the courts are expected to undertake ongoing training and professional development to ensure that they have a sound and contemporary knowledge of family violence. As we saw, that knowledge and what constitutes family violence is changing, and it's not just the physical, it's the controlling behaviour that is certainly of concern. Point 3, it is a worry that it's only parenting matters that are getting this intensive scrutiny. As we know, financial abuse is a major source of poverty and homelessness in Australia, and that often occurs during the breakdown of relationships, separation, divorce. So it's an area in property matters where we have just as much an obligation to consider what are the risk factors concerning family violence that's going on. And for those that aren't aware, the Family Court has a number of different resources that are available around family violence, and Rowena has dropped this presentation in, so you'll be able to, for those that are interested, be able to go and review some of those information and fact sheets and frequently asked questions that should be up to date with the recent changes to the. As far as family dispute resolution practitioners are concerned, we've got some very specific obligations around family violence and risk screening. So before providing family dispute resolution under the Act, the Family Law Act, we've got to make sure that an assessment's been conducted of the parties to the dispute and that family dispute resolution is appropriate. Now, in some of, and I know we've got some people from services, in services, often some of the preliminary work is done by an intake officer who may not be a family dispute resolution practitioner, but it's still critical that intake officers have a current and very real understanding of family violence, and often they may come from a background in family violence support work or other areas. If not, then certainly training to make sure that they're picking up on the more insidious forms of family violence is really important. Regulation 25(2), the second part of this, is in determining whether family dispute resolution is appropriate, family dispute resolution practitioners must be satisfied that consideration has been given whether the ability of any party to negotiate freely in the dispute is affected by any of the following matters. So a history of family violence, likely safety, equality of bargaining power, the risk that a child may suffer abuse, emotional, psychological and physical health of the parties, and any other matters that we consider relevant in this particular circumstance. If we are satisfied, then we can proceed, and if not, we actually must not provide family dispute resolution. So if it's a process where someone's going to be coerced, where they're not able to negotiate freely, then we need to decide about whether FDR is an appropriate process. So this is really complicated and can be quite a complicated decision, because often if someone has been subjected to family violence, they are going to have, in most cases, some ongoing emotional, psychological, and potentially physical health issues. Our thinking has to be around, is that going to affect their ability to negotiate freely? I guess that's part of what we need to think about once we've got that disclosure of risks. With screening for risk, we need to identify if risks exist. History of family violence, the circumstances in most cases will have changed with the separation. However, with the housing crisis we have in Australia, often people are remaining separated under the one roof. And a little bit of audience participation. Do you think separate under the one roof increases or lowers risk? I would think increase. As far as how do we identify risks, intake forms, risk screening tools, information about the clients and information about the conflict are the sorts of things that we need to collect. And then with all of that information, then we need to do that evaluation about, will they be able to negotiate freely? Are the risks manageable? And are they risks clients are willing to take? So my belief, my very firm belief, is that we need to be having these conversations with the clients and discuss with them what their thoughts are about the suitability of FDR and other options that they have open to them. So is it safe to proceed? If it's not safe to proceed, no, we need to not proceed. We shouldn't be providing a process that's unsafe for us or for others. Of course, there are safety protocols and safety planning strategies that we can put in place. If we put those in place, is it going to be safe to proceed? Then yes, we can proceed. If not, then we really need to think about, is another process might be more appropriate. Is it appropriate? And remember, appropriate is in the context, will this person be able to negotiate freely? We all know, anyone who's a current practitioner knows that power ebbs and flows within a mediation process. It may depend on the topic being discussed, and so it's not inherently about whether there's an imbalance of power. It's about whether that imbalance is going to cause an inability to negotiate freely. So we need to constantly come back to that thinking. And if that's the case, and it might be because the person's got a specific negotiation style, so they're themselves holding back, or it might be because there's efforts to intimidate or limit someone's ability to make choices. Clearly, we also exist within a reality of what the environment is for that family. So there might be some inherent restrictions or boundaries or barriers that exist that have got nothing to do with family violence, but there can be others that are put in place deliberately by one of the parties. And I guess that's what we need to be looking at. And then finally, how should we proceed? So maybe we offer FDR services. We may offer them in conjunction with referral to other DV psychological support or legal services. Or it may be that we decide that it's not appropriate and we need to make a mandatory report. Or it may be that there's an imminent risk. So remember, mandatory report is only for child protection matters, and that goes to the state, whoever the state government department is that takes mandatory reports. And then if there was an imminent risk to a person or to property, that would be another reason we might breach the confidentiality of our process to try and get support. For example, you're doing an intake and the person gets all upset and says, that's it, if I can't have the house, no one will. I'm going to go and burn the bloody thing down. And you think it's a credible risk. Then you've got to think, how should I proceed? What should I do? What do you think? Use the chat. If you're in a situation like that and the person hangs up on your call or storms out of the room and says, that's it, I'm going to burn the house down. What do we do? We say, oh, gee, that was terrible. Go on to the next client. Come on, use the chat. Don't be frightened. What could we do? Yeah, absolutely. So if there can be situations where it's a throwaway comment and you don't think it's serious, but if someone's leaving in a really agitated state, then yeah, you might need to take precautions. And if If there's no risks, if they haven't gone out to the petrol station with a jerry can and heading towards the former family home, then there's probably not going to be a problem. If they have, then you might have prevented a serious incident. So I guess we need to think about, just if we're feeling like something is serious, we need to take steps. The same thing if you've got a case where, let's say, there's been accusations of child abuse, it's gone through, it's been evaluated by child protection, there's intervention orders in place. As far as they're concerned, they've closed the case. But someone comes to you, mediation's allowed, and you're helping them to negotiate contact arrangements. Do we just blithely go along there, even though we know that the risk for child protection has changed? What could we do? Nothing? Maybe we could ring child protection and just flag it for the file. Maybe we make a note on our file, but if it's just on our file, it's not going anywhere. It's not going to make a difference. In those sort of circumstances, I'd usually ring up child protection and have a conversation and leave it to them. They have a lot more information about the case than I'm going to get, because they might have interviewed the school, they might have talked to others. So if something I'm doing is changing what would have been a risk rating, how do we interact with others in the sector is what I'm inviting you to think about. So Section 60I certificate, if we don't consider it's appropriate, then we need to issue a certificate if it's related to parenting. But do we just, that's it, close the file, or do we need to think about what happens now? What's the next step for these people? Now, it doesn't seem to want to play. I was going to share a video with the changes to the coercive control legislation that's coming through in New South Wales. They've got a nice range of little videos that they've produced that are really accessible. I'm not going to get to show you, but hopefully you've got enough interest that you'll go out and look for those. But why all this worry about coercive control, particularly if it's not being connected with physical violence? There's a very high correlation between intimate partner homicide and coercive control, like almost 100% on recent reports done in South Australia and New South Wales regarding this new legislation. So coercive control is really where a person believes they have a right to control the behaviour of the other person. There's often a real sense of ownership, and when that's at risk, which is at the time when we're working with them during separation and divorce, it really is a very high risk time for people. Oh, thank you, Rowena. You're wonderful. She's just dropped that down video, or the link to get through to those videos. And look, it could be, though, using videos like that with clients. Often people have been in a relationship with coercive control, talk about things like a frog being boiled in water. I don't know if it's true, but the saying is, if you start off with cold water and slowly increase the heat, the frog stays in the pot. It doesn't realise what's happening to it. And that's often the case in these sorts of relationships. They start off with love bombing, and it's just so over the top and wanting to just love you so much. I want to know where you are at every second of the day. And then it just gets worse and worse once the person's isolated and removed from support. So we know that there's high levels of long-term harm that people subjected to coercive control can experience, because it really attacks right down to their most fundamental sense of identity and personal autonomy. Systems abuse is also really common where there's coercive control, and family law professionals, mediators and lawyers are often used as part of the toolkit to harm and destroy the former partner. So financially and emotionally punish them for daring to leave them. And it's also a risk factor in parenting. Parents who use violence often have a parenting style that really makes it very difficult to really connect with the children, because as they do with their partners, they see the children as an extension of themselves and often lack the empathy to see the child's issues and concerns. So they'll use manipulation and other strategies which are harmful for children as well. When we're hearing about coercive control in relationships, we need to be looking at the flags. And as we know, with the new definition of best interests of the child, part of it is safety, but the other, their right to developmental, emotional, psychological and cultural support, and how well each parent is able to support that. So in our processes, we really need to be considering these things and talking with clients about what supporting the developmental, emotional and psychological support of their child is or might look like. And of course, it's not a single thing. There is not the prescribed style of parenting. There can be a huge range of perfectly safe and appropriate parenting styles, and then there's that is harmful. And we're working in that area of trying to prevent further harm. So the other thing to talk about is trauma. So trauma is a trauma response to a real or perceived threats to safety. And with family violence, particularly ongoing systematic family violence, that people are in a high state of arousal, not a high state of threat, about looking for the threat, looking for the harm, pretty much any time that they're interacting with their abuser. So it can accumulate. It can be caused by a single traumatic event. And trauma, of course, doesn't just result from family violence. It can result from natural disasters, accidents, all sorts of incidents that cause either an excessive spike in that perception of threat to safety or life, or that ongoing inability to feel calm and relaxed. And some of the consequences that you'll often see in clients who've been subjected to family violence is that ongoing consequence. They can be highly activated, so they can be very reactive. Their feelings and their behaviour can be difficult to be around because they've been living in that way for so long that they're very easily triggered. We need to think about triggering in terms of the way that we risk screen and the way we interact with clients, and also making sure that we're working in a trauma-informed way. If you think about trauma-informed and what's that really look like anyway, there's some good resources around. Blue Knot is an organisation that's focused on recovery from complex trauma, and particularly childhood trauma. In a study in 2015, they estimated 1 in 4 adults had experienced significant childhood trauma. And we know that the consequences of childhood trauma affect relationships in later life, affect the way that children are able to interact with others. If you have more than 3 clients, statistically, you're going to be working with people that have got trauma histories. So we need to work in a trauma-informed way with clients, because it may be trauma responses that have been laid down earlier in their lives that they're still being affected by. The comment hurt people is one that can be a little bit controversial, in that sometimes people think that excuses users of violence, but that's certainly not the intention in sharing that. It's really looking at understanding that often there's a cycle of abuse that's ongoing, and part of our role, I believe, is to try and support the interruption of that cycle so that we can reduce that statistic down. Oh, yes, this is the screen I was looking for. So trauma-informed services, so just attuned understanding that it's highly likely that the people you're working with have got trauma histories of one form or another. Some of the principles, so from this research, principles of safety, trustworthiness. So being very, very clear about what we're doing with clients, very open where we're able to within the bounds of confidentiality, and making sure that we do what we say we're going to. Surprises and trauma don't go well. Giving people choice, making sure that they do know what their options are and you're able to talk through those collaborations, looking at ways that you can reduce the number of times that people have to go through their story, looking at how, so for example, if you're using doors, Are you able to get permission to pass on a recent screening to the next service? Looking at a warm referral where you're able to provide the basic details so that people don't start from a scratch from a phone call. And if anyone's that's on the call, if you've got examples of how you're doing that in your services to try and help, using collaboration to try and help reduce the risk of re-traumatizing or making services more difficult for people than they need to be, please share. And accommodating the vulnerabilities, including for people from diverse backgrounds. So we've got many people coming to Australia that have come from war zones, come from really terrible life experiences. So they're already coming with all sorts of potential traumas that they might need additional support with. Really promoting healing, so making sure that we're building on a strengths-based framework and we don't see people as broken, but rather as people that need support to achieve their potential again, and continually talking about safety. So if anyone's, feel free to use the chat to share your thoughts on or perspectives on trauma-informed work as well. But really the importance of respect, dignity and hope. So making sure that while we're using empathy, we're not treating people as if they're incapable or don't have capacity. If we find someone who really is in a very difficult space like that, then we need to do everything we can to help them to get the psychological support that they need. But in most cases, we're dealing with the walking wounded. We need to show respect for that and support people in the way that we're working with them. Just a reminder, the importance of using standardised processes for screening. It, again, makes information sharing easier when there is a risk of harm identified. So we're talking the same language as other services. It ensures that all practitioners are complying with the obligations to risk assess. We're only human, and that risk that our own biases can come through, that we see a well-dressed, put together looking person and don't ask the questions because surely they couldn't be subjected to family violence or they couldn't have vulnerabilities. So if we make sure we're asking the questions of everyone, because that's of course a complete myth, family violence and coercive control can be happening in any relationship. And using evidence-based tools extends our personal experience and knowledge level. And it really, I guess I see it as very important, particularly as things change and our tools update. It can prevent particularly long-term practitioners from just relying on what they knew as being what they now need to know. So we really need to make sure that we're using tools that are current and tested to ensure that we're correctly evaluating risks. The risks we're looking at is historical risks and protective factors, and also the current risks and protective factors. So separation, as I mentioned before, could have increased risk or it could have reduced risk because now they're in a different environment, safer environment. There's family violence orders. There's no evidence of breaching those orders, and there's been an acceptance. Or it could be that they're that same thing, but they feel like there's some violence happening, that the orders might have been breached, and there's a concern that the person who uses violence isn't respecting the protections that are trying to be in place. So those things together are going to contribute to the risk assessments that we're making. And I don't have green for go when there's no risk at all, because I find that's unsafe. So we need to think about moderate to low risk based on the historical and current factors versus high risk. So is it a red or an amber flag? Because the context that we're working is inherently a risk factor. Now I'm talking a lot, I'm not getting a lot of interaction in there. Are there any comments or questions on anything that I've discussed so far or said so far? No, we're so another element I just wanted to bring out is around psychological distress. So a definition for psychological distress: unpleasant feelings and emotion that affect function. It certainly can be common legacies of family violence. Sometimes it can be without family violence, but just the process of separation can cause a high levels of psychological distress. So if one person's made the decision to separate and the other person wasn't aware, that can often be a source of significant distress, and talking about ways for them to get some support so that it doesn't continue and escalate. And often when people have got high levels of psychological distress, they may use very healthy and effective ways. They may go out into nature and they may meditate and they may do all sorts of wonderful things, or they may use substances or alcohol or other temporary relief measures that don't actually really assist their mind and body to recover from the source of the distress. Mental health could be seen as being a state of high functioning and resilience. It doesn't mean we don't have down days, doesn't mean that we sometimes don't get stressed, but it means that we're not in a constant state of that. So the psychological distress is really at a highly stressed, intrusive thoughts. Okay, yeah, an example of contraventions of AVOs multiple times. Yeah, look, it's a real concern. There's still a process of education and bringing a whole system and every person who works in it up to the level where they should be operating. There's often a lack of understanding. And if you look even at the reports from the media about some of the recent murders, intimate partner homicides, we can see as professionals working in the field how many warning signs there were before that incident happened. I'm hopeful that the changes in the Family Law Act, looking at the violence that occurs towards anyone that's caring for a child, will help some of those problems with the relationship of the parent to the child was prioritised or appeared to be prioritised over the safety of all of the family members involved. Time will tell whether changing the law changes some of the practice. It's probably not enough time. It's only a month. Anyone who's also working in the court, if you've seen a miraculous change, please let me know. Reducing risks through engagement. We can't effectively evaluate risk and encourage people to take protective, preventative or restorative action unless we can engage with them, unless they tell us what's going on and they have enough trust in us to actually consider some of the information we can provide them. We need to engage with those at risk of harm, and we also need to engage with those at risk of causing harm. I suppose normalising stress so that people don't just get into a worse cycle, but also normalising getting support for stress and working with psychologists or counsellors or coaches or whatever when they're going through a difficult time. Also recognising distress, so extreme worry, sadness, pain, particularly hopelessness. Hopelessness can be a very dangerous state for someone, particularly someone who's got a history of using violence in the past. Noticing coexisting risk factors, so compounding factors that can cause just an overload and tipping point, which may lead to an incident of violence, or it may lead to a psychological breakdown, and so on. Doing whatever we can to help people to connect with resources to relieve some of the stresses. That's why with DAWS you'll see that it asks about housing, financial stress and other things as well, because they can all contribute to make the situation worse. Responding effectively, discussing your concerns with clients. So again, wherever possible, it's really important to talk to clients where you can about their situation, your concerns, show them the respect, being part of the discussion. And I noticed in the chat, thank you, Karen, you talked about the new Family Law Act, the amendments of the voice of the child. So again, it's always been there. We're signatories to the international rights of the child. Children have, under international conventions and under our Family Law Act, the right to have a say in matters that affect them. Through the lens of family violence, we need to consider how can we safely encourage that. So child inclusive practice can be really helpful. However, where there's a parent who's coercively controlling the family members, it may not be an appropriate process to use in that circumstance, because the feedback may not be something that they're able to tolerate and make it worse for the family. So please, if you're an FDRP and establish some relationships with child inclusive practitioners, really have a conversation with them about who are the right people to go to the process. Is this a situation that taking the matter to the court is going to be better for those children? Are there going to be more resources and scrutiny that could assist to identify the issues? It's going to depend on the circumstances. And also consider, is it possible with your services, if someone's at significant risk, to check that the handoff has worked, that they have now got other specialist supports available? So there was a question about how do we engage with a person who we believe's got a potential of causing harm without stepping away from your neutral role. And look, it's a good question. I think we can, in a lot of ways, if we're talking in a really clear and factual way about the behaviours, giving them information about what is considered coercive control, particularly often people who don't have that awareness that it's not okay for one person in the family to control everyone else, who thinks a man's right or a man's job or responsibility in that a very classic gender-based scenario, which we know is still very prevalent in many cases. I guess if we really need to look at how do we have that conversation about accountability without it being a blaming and shaming situation. Sometimes it can be asking, how do you think that is? What do you think that's like for the other person? Sometimes they have enough insight to have some reflection that way, sometimes not. Sometimes it may really be the need to look at referrals. So often in those situations, you might have someone who's trying to reconnect with their children, who's had their spending time arrangements. You might be able to talk about some of the courses and programs that are available that could help to restore trust and build confidence and allow those relationships to build back. Long-winded way of saying, what are the needs, what are the values that are underpinning that person? Because unless they're an absolute psychopath, there's probably some beliefs around the justification for their behaviour. So safety planning for FDR, just looping back around, if we are going to proceed, how can we minimise the risk and ensure that they're able to negotiate freely? Do we consider, are we going to bring them together in person? Do we offer online? Do we offer shuttle so they don't have to see or speak to each other directly? And again, it does concern me sometimes doing shuttle in the context where you're negotiating arrangements where there's spending time arrangements and people are going to be having unsupervised contact. They're not able to speak with each other with the support of an FDRP. How is that going to work? Whereas if it's another context and they need to speak in order to sort out what's going to happen with property and some contact for children, then shuttle might be very appropriate. So again, we need to look at every case individually. And when we know that there's a history of, particularly where there's been abusive language, be really mindful of setting those ground rules, not allowing pet names, really enforcing respectful language, not permitting our process to be misused. And I know there's often some debate about whether we need ground rules or not. I think if people have a history of being disrespectful to each other, then yes, we might. And then thinking about what's your plan if things do get out of control. And I've got another webinar that'll be coming up in the future about what do we do when things go wrong. So really looking at some of those. Again, satisfied that FDR is appropriate, consider the safety and ability to negotiate and determine risks. So having whether you're working independently and you're going through this together, if you are, then participating in supervision, group supervision, or having a network of several other FDRPs that you can ring up and talk it through, and they can do the same with you. Those are really protective factors for you and for your clients. So these are really hard decisions at times, and it really helps to have a brains trust. If you're working in an FDR service, then often they'll have case management meetings where the more difficult ones are brought together. So yeah, look at also how we resource ourselves as professionals. The other aspect is safety planning with clients. If we've identified that there's current risk, then safety planning is really something that we should be raising with clients. It's exactly like having a fire plan. So if you live in the bush anywhere in Australia, you should have a fire plan. What are you going to do if a fire breaks out? How soon do you leave? How do you get out? What if your exit's blocked? What do you do then? All of those sorts of things. But this is in the case of family violence, risk escalates. So if this is not something that you're comfortable doing, there's probably something to add to your professional development plan. Usually this will be in a context where you might have issued a Section 60I, so you're not going to be so worried about your ongoing independence. But if you don't have the resources, refer them on to Domestic Violence Service. Interact Support, the not-for-profit. We have the capacity there to provide safety plans for people. So you can refer them through. That's a free service just as a support for community. And also, so safety planning, the critical thing, it's a done with you process. It is not a done to you process. You don't do a safety plan to someone. You work with them for them to consider, because they know what the protective factors are in their life. They may not always correctly evaluate risks. We wouldn't have so many people murdered by their partners if the person in the situation was able to accurately evaluate the risk. It's that frog in the pot of water again. Sometimes it can creep up on them and they just don't notice how things have started to escalate, or they may not realise that there's going to be a step change in the risk because of the separation. Mandatory reporting, again, if child abuse or neglect is suspected, we must make a mandatory report unless we're confident that it's already been made. If we're aware that the risk factors have changed, even if there has been a report being made, it's still possibly something that you should do, make another report. Australian Institute of Family Studies has got some good resources on mandatory reporting. So if you're unsure or you haven't checked into that for a while, make sure that's a good resource. I'm not going to have time to go through these tables, but they're pretty self-explanatory. So dealing with low risk but stressful, dealing with moderate risk of harmful behaviour, and then the high risk things. So please, mandatory report goes to the authority in your state or territory. So the page on the Australian Institute of Family Studies website has the links for who that is for each state and territory. Depending how they're organised, sometimes you need to know exactly the location of the client because you have to ring the right section of the department to make the reports. Yeah, that's information you need to get onto your resource list for yourself to know what to do. Separation violence, it's what I'm talking about, that there is where violence has occurred, but there's no history of violence. So this is not where there's been a pattern of violence throughout the relationship. Again, they need to get better strategies. It's still a maladaptive response to the distress. And the critical thing is we really want to try and engage with people who've used violence to get the support they need to get better strategies, because this relationship may have ended, but the drivers that have driven them to behave in this way with their partner are likely to going to lead them to the next relationship, and the same pattern will continue. Really trying to see whether we can be a point of inflection for people. Again, some of the resources and it's always useful to look to the latest legislation that's coming through, because the information that's provided around that can provide a lot of support. Legal Aid in New South Wales they've got some upcoming sessions in person, I think sold out, and there's online. I'm not sure if that's sold out yet or not, but there's a pile of resources there for the new coercive control legislation that's coming through in New South Wales. So thank you for your attention, hopefully, and for the interaction for anyone that was able to. I will stop the recording.